everybody, it's attorney Veronica McClendon, and I want to talk to you about something that I encounter a lot, and I'm hoping that I can prevent you from falling into a trap that a lot of families fall into when they are dealing with heirs property. Specifically, a lot of times families come to me with heirs property, which means that they have property that was passed down from an ancestor. It might be a grandparent, a great grandparent who owned a piece of land or a house, and that property has been in the family for a few generations perhaps. So heirs property is property that's been passed down from one generation to the next without formally transferring the ownership of the property after family members have died. So perhaps someone died in, let's say, 1950, and when they died they owned a house, they owned 100 acres of land. And after they died, their family just continued living in the house, continued farming the land, they continued paying the taxes and doing all of the things that a person does when they own property. But the family did not take the steps to take the ownership out of the name of the deceased ancestor and transfer it into the names of living descendants. So that's one situation that happens. But then heirs property can also happen if a family member dies and the family does take legal actions to transfer the property, but they do it in a way that now we have a lot of members of the same family owning one property. So an example of this might be that, again, maybe a grandmother dies, and when she dies, her children decide that they're going to transfer the ownership from her to the children. They go through the probate process, which we'll talk about in a moment, and then they put the property, either they get someone appointed over the estate and they stop there, or they actually take the steps of having the administrator or the executor of the estate to sign a deed into the names of the other family members. They do this, but then as time goes on, that property is still owned by several members of the same family. And as those individuals die, their children inherit an interest in the property. So then what we end up with is multiple generations of people owning an interest in this family property. And that situation just gets worse over time as more and more members of this family end up owning an interest in this property. So when we have those kind of situations, a lot of times families will think, I want to save money on lawyer fees, so I'm going to go ahead and probate the estate, because I know that when someone dies, you have to probate their estate. So I'm going to go ahead and get that part taken care of. But what those individuals might not be thinking of is the situation where after the original family member who owned the property has died, now some of their children or all of their children have also died, and the property is now owned by various grandchildren and sometimes great-grandchildren. Or it could be a mix of children, grandchildren, and great-grandchildren, depending on what happened in the family. So they'll go and actually probate the estate, get an administrator appointed over the grandmother or the grandfather's estate, but then they don't realize that you also have to do work to administer the estates of the subsequent generations. And I always encourage people I tell people, look, we need to do an assessment of your property first before you start probating estates, because probate might not even be the best option in your situation. So the situation I just talked about, where ancestor died a long time ago, 1950, they had 7 children. Now all 7 of those children have died, and we're dealing with the children of those children and sometimes the grandchildren. We probate the estate of the ancestor who died in 1950, but then there are also these other deceased heirs. The problem is that the probate court does not have jurisdiction to determine who inherited from those deceased heirs. When you file a petition in probate court, the probate court gets jurisdiction over one estate. So let's say you file the petition to probate the estate of the grandmother or the great-grandfather. You probate their estate. The probate court can't determine who the heirs of their deceased children are. And so that creates a problem. What I encourage people to do is let's assess the title. We want to, work with a lawyer first who understands all of this. get them to prepare a family tree. Well, get the family to prepare a family tree, bring it to me as the lawyer, and I, as the lawyer, will order a title search. When I'm ordering that title search, I'm going back to the first person in the family to own this particular parcel of land. And then I determine, how did that family member get ownership of the property? How did they acquire ownership of the property? Then I trace the title forward to get to the current situation to see if perhaps, great grandma may have owned this property. She may have been the one who bought it from someone. But then when she died, it got into the hands of her children. Little do we know, one of the children has already sold their part to either another of the siblings or someone else in the family, or perhaps they've sold it to someone outside of the family. Or it's possible that they have liens in their name that have attached to the property. We won't know these things unless we actually go through and do a title search. So we do the title search. We compare the information we find in the title search to the information that we have in the family tree. Then we determine our strategy. Our strategy could be probate. We might say, you know what, it makes sense in this case to go ahead and get an administrator over the estate. Perhaps we're trying to cut some timber, and we can get an administrator appointed to get authorization to cut the timber and sell the timber. And then we can work out the other estates as we go along. Maybe we use some of the money from selling the timber to actually help open up estates for some of the subsequent family members who have died, so we can deal with their estates as well. Once we open estates for those individual family members, then the probate court has jurisdiction over their estate to determine their heirs. And basically, we can create a tree that is built off of what has happened in the different probate court proceedings. So we might determine that's the best route. Or we might say, this is something we need to just deal with in superior court. Because a common misconception is that with probate court, people think this person died, they had an estate. Oftentimes, the only property in that person's estate may be land. And so the family might tend to confuse the difference between who owns the land and who has rights to the estate. It could be the same group of people, or it could be a different group of people. For example, the heirs of an estate for someone who died in, let's say, 1975. The heirs of that person might be their children. Or perhaps one of their children died before they did. So this person who died in 1975, their heirs consist of some of their children, but then the children of their deceased child. So those are their heirs. But between 1979 and 1975 and the present, some of those group of people have also died. So then we have the heirs of those heirs. Again, probate court cannot determine the ownership of those individuals, but the superior court has the legal authority to determine the owners of the real estate. So superior court can determine who all of the owners are based on people who have died at different points in time. But probate court only has jurisdiction over a particular person's estate. They only can determine who a particular person's heirs are. Superior court can determine all of the owners of the property. And I think I forgot to mention that this is Georgia law I'm talking about. I don't know what the courts in other states might be called. There might be other strategies that make more sense in other states. Here in Georgia, this is the kind of situation I'm talking about. So you got to make sure that you find an heirs property lawyer in your state, because all of the states have different laws. All states have different ways of determining a person's heirs. All states have different levels of jurisdiction as to who has the legal authority to determine the owners of land, who has the legal authority to determine the heirs of an estate. Usually it's going to be probate court for heirs of an estate, but it could be different in your state. I don't know. I've only studied Georgia law. There's 49 other states and then territories that I have not studied, so I don't know what is going on in those states. Another thing that's a possibility is that we might determine we're not going to probate court. We're not going to superior court because we have all of the family members here. We can deal with this outside of court. we can get the heirs to create an agreement, and we can have them to sign various affidavits, transfer deeds to be able to clear up the ownership of the property. So you might not even need to go to court in some situations. And a lawyer can help you to determine that. I do encourage you, when you are working with a lawyer, if you're dealing with heirs property, you need a real estate lawyer, a probate lawyer, and maybe even a small business lawyer, depending on what you're trying to accomplish. If you want to create an LLC or a trust, you might need a small business lawyer. But at least you're going to need someone who has real estate background and probate background. Someone like me, I have experience and expertise in all of those areas just because I focus on working with families who own heirs property. However, if you don't have someone who does all of that, then perhaps you can get different attorneys to work together to come up with a solution. One person is looking at it from a probate angle, the other attorney is looking at it from a real estate angle. You also, in terms of thinking about the future of the property, need to look at an estate planning lawyer. Again, a firm like mine, we keep all of that under our roof, but other firms may have more specific specialization, and they may not handle all of those areas. But what I don't want you to do is to have your family member who is a criminal lawyer dealing with this. Oh, I could just have them do an estate for me real quick. Because I had that happen. One of the cases I had early on in my heirs property career, the family had a family lawyer. They had the family lawyer to open an estate. And it turned out that the estate didn't even own the property anymore. The children of the deceased, of the original owner of the property, had already divided the property between themselves. As soon as their ancestor died, as soon as their father died, they already decided how the property was going to be set up. Now, there was some legal work that needed to be done, but probate court was not the case for this situation. So these are the kind of things I want y'all to think about. Also, in that particular situation, there was the original, the father who owned the property. When he died, it was split between his children. Now, if we went to probate court and opened an estate for each of those children, maybe that would have been a good route. But in this case, we did not do that. They opened an estate for the parent, and his estate didn't even own the property. So we had to go through a whole long legal process just to get the property out of not get the property out of the estate, to close the estate, so that we can actually deal with the real estate, which was owned by the descendants of that original owner. So I'm telling y'all all this because I don't want y'all to go through this. It costs a lot of money. It's a lot of stress. Families confused. They're like, I thought we dealt with that, and now we're going to court again, or now we're having to go through court just to undo what we did in court. I don't want y'all to go through that, because once you open an estate, in order to close it, you have to file a petition for discharge, or else the court is going to be saying, hey, we need our annual reports. Why aren't you providing us with updates? And then if something happens, then they're going to be coming to you and saying you didn't do your job. So I want y'all to avoid that kind of situation, and want to make sure that you know your strategy ahead of time so that you're not cleaning up things along the way. So if you need help with that, if it's something that you want to talk with my firm about, feel free to give us a call or schedule a consultation. If you have property in Georgia, if you're outside of Georgia, we're not able to help you right now. The best we can do is refer you to someone, but we'd rather you not contact us for that, because we've kind of been having a lot of people asking us for referrals. We'll work on a solution for that. What I want you to do is to join my email list. That way we can share updates with you. And once we have a referral list of all of the attorneys around the country that we recommend, we can send it to you. But until then, join my email list. If you have Georgia property, feel free to reach out to us. Other than that, subscribe to this channel, like this video, and share it with someone who you think will find it helpful. Thank you so much for tuning in. Again, my name is Attorney Veronica McClendon. I'm licensed in the state of Georgia, and I love talking to y'all about heirs property. So let me know if there's other things that I can talk about that you'll be interested in. Y'all have a great one, and take care.